Good morning, everyone. My name is Gloria Vinci. I'm a real estate lawyer with Vinci Phillips. This is your legal tip of the week. You probably have dealt with situations where the seller has agreed to do certain work before the transaction closes. That usually is put into the contract, and we as real estate lawyers obviously zero in on that. However, you have to go one step further, and you have to provide a term of the contract that will allow the buyer to do a holdback subject to the work being done. Because if there's no holdback provision by the buyer in the contract, as you know, there are no holdbacks. My preference, and I think probably I'm speaking for a lot of real estate lawyers, my preference is to give a credit, a certain amount of money to the buyer for having certain work done, if possible. In this way, the transaction closes without any hitches. There's no, there's no back and forth between lawyers as to what the seller has or has not done. So it's a clean deal, and the transaction closes, without any problems. The other thing to keep in mind when you're giving credits from the seller to the buyer, and I'm talking about any general situation that might apply to that. And that is that if the credit to a buyer in a real estate contract is significant, the buyer's lender has to be made aware of this reduction in purchase price. Because if not, the buyer's lender can take the position that they would not fund the mortgage. Please call me, or I should again say email me at gloria@vinciphillips.com if you have any questions. Thank you.